I am delighted to have been invited by President Knežević to contribute to this year's Judicial Forum. I'm sorry that I can't join you live, as I'm sitting in a hearing of our court on the 25th of May. Instead, I've recorded this presentation. The last year has presented significant challenges for courts in both our jurisdictions, and indeed for courts across the world. We have had to adapt to working remotely, at a distance not only from our colleagues, but also from the parties and the public. With our court buildings closed, we have had to find new ways to ensure that justice is done and is seen to be done. This is an opportunity for me to share with you our experience of dealing with these challenges in the UK Supreme Court. I hope you may find something which is of value to you when thinking about how these matters might be addressed in your own courts. I'm going to focus on three aspects of our work: the conduct of hearings, the delivery of judgments, and the provision of educational programs. Over the last year, the most significant change has been to how we conduct our hearings. Before the pandemic, every appeal was determined following a public hearing held in our court building in London. It became apparent during the week commencing the 16th of March last year that significant changes to working life and travel in the UK were liable to be introduced in response to the spread of coronavirus. During the course of that week, the court moved rapidly to develop a web conferencing system for holding hearings and to train the justices in its use. The Prime Minister announced lockdown in the United Kingdom on the 23rd of March last year. The next day, the Supreme Court held its first online hearing, with the justices working from their homes and counsel either in their homes or in their offices. The hearing was held using the Cisco WebEx platform. The court has continued to operate in this way for all hearings since then. Throughout the pandemic, we've been determined to ensure that our hearings remain accessible to the public. We've therefore continued to live stream all of our hearings on our website. Although members of the public cannot currently come and sit in the public galleries of our courtrooms, they can still observe all our hearings as they take place. The recordings are uploaded onto our website afterwards, so there's an archive of all our proceedings which can be viewed at any time. Here is an example of the beginning of a hearing. Welcome to the Supreme Court of the United Kingdom, where today we're hearing the appeal in the case of Lloyd and Google. The case is concerned with a claim brought by Mr. Lloyd, alleging that Google breached various duties under the Data Protection Act to users of Apple iPhones, and the issue for the court is whether Mr. Lloyd should have been refused permission to serve a representative claim against Google out of the jurisdiction of England and Wales. I'm hearing this appeal with four colleagues whom I'll introduce now. First Lady Arden.
Good morning.
Lord Sales.
Good morning.
Lord Leggett.
Good morning.
And Lord Burrows.
Good morning.
We'll be hearing first the submissions on behalf of the appellant, Google, who are represented by Mr. Anthony White, Queen's Counsel, and Mr. Edward Craven. So I'll invite Mr. White now to begin his submissions.
My lords and my lady, in this appeal I appear with Mr. Craven for the appellant, Google LLC. My learned friends Mr. Tomlinson QC, Mr. Campbell QC, and Ms. Wakefield QC appear for the respondent, Mr. Lloyd. My learned friends Mr. Ficena QC and Mr. Grubeck appear for the Information Commissioner, who's been given permission to intervene and to make oral submissions. There are 5 other interveners who have been given permission to intervene by way of written submissions. My lords and my lady, the case raises important questions of law relating to the meaning of damage in section 13 of the Data Protection.
The use of video conferencing technology has required a significant commitment from our IT team and other support staff. For each hearing, guidance on arrangements is sent to the parties in advance, and our IT team conducts pre-hearing test sessions with counsel. Both the test sessions and the hearing require 2 members of the IT team. One member is on hand to deal with any technical issues and to provide support or handle queries. The other member of the team prepares footage from previous days for publication online and ensures that the live feed is stable and runs properly. Overall, the feedback we've received from users involved in remote hearings has been very positive. Some minor technical problems were encountered in the initial hearings, but were addressed. We also adapted the system in response to user feedback, for example, so that it's possible for those watching the live stream of each hearing to see all of the justices at the bottom of the screen, as well as the person who is speaking. We're conscious that participating in a remote hearing is a different experience from taking part in a hearing in court. Counsel have reported that remote hearings are more tiring and that it can be more difficult to involve junior counsel and to take instructions during the hearing. We've responded by introducing a short break mid-morning and by allowing adjournments when instructions have to be taken. We're also conscious that there's not the same spontaneous interaction between the participants in a remote hearing as there is in a courtroom, and the experience for litigants and members of the public is also very different. So we're looking forward to returning to hearings in the court building as soon as it's possible to do so. Turning to judgments, our efforts to ensure openness and accessibility continue after the hearing. Once we have reached a decision, we take a number of steps to help the public understand what we have decided and why. These have been largely unchanged by the pandemic. First, all our judgments are published in full on our website. Each is accompanied by a short video in which the justice who has written the lead judgment explains what the case is about and what the court has decided, in language which non-lawyers can understand. The videos are streamed live on our website at the time the judgment is handed down, and are then made available afterwards on our website and our YouTube channel. We also provide a written press summary of each of our judgments. The summaries cover the factual background to the appeal and the reasons for the court's judgment. They are written in plain language and are intended to support accurate reporting of our judgments by the press. Here is an example. Turning next to education and outreach, transparency is not just about explaining what we have decided in individual cases, but also improving public understanding of our role and functions more generally. When I spoke to you in Sarajevo in 2019, I emphasized the importance of physical access to the court building in that regard. I told you about our open days and tours and our gift shop and public cafe. It has not been possible to provide public access of that kind during the pandemic. Our building has been closed for almost all of the last year. So we have moved our education and outreach work online. We have developed a 360-degree tour of the Supreme Court building, which enables members of the public to explore 3 of our courtrooms, our main event spaces, and the Justice's Library on our website. You can see it here. We also offer interactive tours on Microsoft Teams, which are led by an experienced tour guide covering everything from the role of the court in the UK Constitution to the history of the court building and the artwork displayed there. Since June of last year, we've conducted 85 virtual tours for schools, villages and universities across the UK, and 15 virtual tours for governmental and other public sector organisations, including the Houses of Parliament and the Ministry of Justice. We recently started offering guided virtual tours to members of the general public. We also run other programmes which give school and university students the opportunity to interact directly with the justices. So far this year, we've run 9 Ask a Justice sessions, which are live question and answer sessions between a group of students aged 16 to 18 and the justice of the court. Here are some photographs. We have also run 5 university mooting competitions, each judged by a justice, and we've run 15 debate days, during which young people are given the opportunity to prepare and participate in a debate on a topical legal issue, coached by professional lawyers. We have also expanded the range of educational materials that are available to download on our website. There are lesson plans on human rights and the separation of powers for students aged 16 to 18, and there's even a Supreme Court colouring book aimed at children under 11. Here's an illustration. In many ways, the changes brought about by the pandemic have enhanced our education and outreach work. By making everything available online, we've been able to reach schools and colleges that are too far away or don't have the resources for a visit to London. We've seen an increase in participation from students from Scotland, Wales and Northern Ireland, as well as the north of England. This strengthens our message that the Supreme Court is a court for the whole of the United Kingdom. Looking forward, we are currently preparing to return to the court building. For as long as social distancing continues to be necessary, we'll only be able to use our largest courtrooms, and staff will be working in the building on a rota basis. Home working and the use of web conferencing for a proportion of hearings may continue to be necessary for some time. Our intention, however, is to return to hearing all appeals in person and to welcoming members of the public back to the court building as soon as we can.